The year is 2026, and America is preparing to execute more prisoners than it has in years. From cold-blooded killers to controversial convictions, this is the chilling list of every man marked for death and the brutal methods the justice system plans to use. Some will die by lethal injection. Others may face nitrogen gas or even the firing squad. These are their crimes. These are their final days. If you're into deep dive true crime coverage, subscribe and hit the bell. Let's uncover what these cases tell us about justice in America. Execution case. January 2026, Quezy Bryan, Ohio. Quezy Bryan remains the only individual formally scheduled for execution in January 2026, with a date set for January 7th. Convicted for the 2000 murder of Cleveland police officer Wayne Leon, Bryan's case has been marred by delays, legal challenges, and conflicting reporting. While his execution is on the official calendar, it's not consistently listed in national summary schedules, likely due to Ohio's uncertain lethal injection logistics and pending litigation. Nonetheless, state records confirm his warrant is active, making him the earliest confirmed execution of 2026. Execution case, February 2026, Antonio Sanchez Franklin, Ohio. Who is Antonio Sanchez Franklin? Antonio Sanchez Franklin is a death row inmate in the state of Ohio, convicted for a brutal and senseless killing that occurred in 1993. Now, over 3 decades later, he is scheduled to be executed on February 11, 2026, making him one of the first Americans expected to face capital punishment in that year. Franklin's case is part of a slow-moving wave of executions in Ohio, where legal battles, lethal injection controversies, and logistical delays have created a significant backlog of death sentences. In Montgomery County, Ohio, Antonio Sanchez Franklin was convicted of aggravated murder during a robbery that shocked the local community. The crime involved the fatal shooting of a Dayton man, reportedly during an armed robbery in which Franklin was attempting to steal money and other valuables. Evidence presented at trial showed that Franklin acted with premeditation and malice, using lethal force even though the victim posed no physical threat. Prosecutors argued that Franklin had ample opportunity to flee the scene, but chose instead to execute the victim, making it a capital case under Ohio law. Since his sentencing in the 1990s, Franklin has spent more than 30 years navigating the complex appeals process, a journey that included direct appeals to the Ohio Supreme Court, multiple post-conviction reviews, habeas corpus petitions filed in federal court. All of these appeals were eventually denied. By early 2024, Franklin had officially exhausted all legal remedies, paving the way for Ohio Governor Mike DeWine to sign his death warrant, formally scheduling the execution for February 11, 2026. Ohio law currently designates lethal injection as the primary execution method. However, due to supply shortages and public controversy over the drugs used, executions in Ohio have been paused multiple times in recent years. In Franklin's case, the state intends to proceed under the standard 3-drug protocol, which includes 1. Midazolam, a sedative, 2. Rocuronium bromide or vecuronium bromide to paralyze the body, 3. Potassium chloride to stop the heart. The Ohio Department of Rehabilitation and Correction, ODRC, has not confirmed whether the drugs are currently available, which leaves logistical uncertainty around the actual date. However, state officials have insisted that Franklin's execution remains active and pending, barring any federal injunctions or last-minute clemency. Execution case, March 2026, James Earl Trimble, Ohio. Who is James Earl Trimble? James Earl Trimble is a convicted triple murderer from Portage County, Ohio, currently scheduled to be executed on March 12, 2026. His name is etched into Ohio's capital punishment history due to the gruesome nature of his crimes, his unwavering admissions, and a case that shook the state's criminal justice system in early 2005. After years of court battles and unsuccessful appeals, the state of Ohio has confirmed that Trimble's execution will proceed, barring any last-minute stays. His case is often cited in true crime discussions due to its tragic victim profile: a mother, her young son, and a police officer. On the night of January 21, 2005, James Earl Trimble went on a violent rampage after a dispute with his girlfriend, Renee Bauer, in Brimfield Township, Portage County. Trimble, then 45 years old, was reportedly angry and emotionally unstable. He had a history of domestic violence and drug use. That night, following an argument, he shot and killed Renee Bauer and then executed her 7-year-old son, Dakota Bauer, who had tried to hide in a bedroom. After the double murder, Trimble fled the scene and went into hiding in a nearby apartment complex. The next day, as law enforcement swarmed the area to locate him, Trimble took a female neighbor hostage and held her at gunpoint in her own apartment. As a SWAT team tried to negotiate with him, Brimfield police officer Marty Martin, a 31-year-old father of two and a U.S. Marine Corps veteran, was part of the entry team that attempted to free the hostage. When officers breached the apartment door, Trimble opened fire, shooting and killing Officer Martin. Trimble was ultimately arrested after a standoff and confessed to all 3 killings. Trimble was indicted on multiple counts of aggravated murder, kidnapping, attempted murder, and weapons violations. Prosecutors sought the death penalty, citing the heinous and calculated nature of the crimes, the murder of a child, the deliberate killing of a law enforcement officer performing his duties, the use of a hostage during a standoff. In 2006, a Portage County jury found Trimble guilty on all counts. He waived his right to present mitigating evidence, claiming he deserved death and wanted the families of the victims to have closure. The judge sentenced him to death for each of the 3 murders. Trimble's confessions, courtroom demeanor, and decision to forego mitigation surprised many legal experts. In his words, "There's nothing to say to explain why I did it. I deserve to die." Although Trimble accepted his sentence, state law requires automatic appeals in capital cases. His legal team later filed several appeals arguing ineffective assistance of counsel for allowing him to waive mitigation, mental instability and suicidal ideation, use of drugs, including methamphetamine and crack cocaine, prior to the killings, failure to fully investigate childhood trauma and brain injuries. Nevertheless, Ohio courts upheld his conviction and death sentence at every level, including the Ohio Supreme Court and the U.S. Sixth Circuit Court of Appeals. In 2018, the U.S. Supreme Court declined to hear his final appeal, making his sentence legally final. James Earl Trimble is set to die by lethal injection, Ohio's current execution method. Like other inmates scheduled for 2026, his execution will use the standard 3-drug protocol. The murder of Officer Marty Martin deeply affected the Brimfield and Portage County law enforcement communities. Numerous memorials were held, and the Brimfield Police Department continues to honor his memory annually. Dakota Bauer's family described the young boy as playful, kind-hearted, and protective of his mother. The double homicide of mother and child left a lasting emotional scar on the community. Execution case, June 2026, Gerald R. Hand, Ohio. Who is Gerald R. Hand? Gerald Robert Hand is a former funeral home owner and convicted murderer from Delaware County, Ohio, who is currently scheduled to be executed on June 17, 2026. Now in his 70s, Hand has been on death row since 2003, following one of the most twisted murder-for-hire schemes in Ohio criminal history, a case that involved multiple wives, staged robberies, and calculated betrayal. In January 2002, police were called to Gerald Hand's home in Delaware County, where they found his 4th wife, Donna Hand, shot to death. Nearby, the body of Walter Mitchell, a former employee of Hand's funeral business, also lay dead, allegedly killed by Hand in self-defense. Hand told authorities that Mitchell had broken into his house and murdered Donna during a robbery attempt. Hand claimed he shot Mitchell in defense of his wife. But investigators quickly found problems with the story. Upon closer examination of forensic evidence, the case began to unravel. The trajectory of the bullet wounds didn't align with Hand's account. Mitchell had no apparent motive or history of violent crime. Donna had just recently changed her life insurance policy, naming Hand as the beneficiary. Gerald Hand had 3 previous wives, and 2 of them had died under suspicious circumstances, with no one ever prosecuted for their deaths. Authorities dug deeper and discovered a disturbing pattern. Each of Hand's deceased wives had been insured, and each death provided a financial benefit. With Donna's killing, the pattern became undeniable. Prosecutors alleged that Gerald Hand hired Walter Mitchell to kill Donna Hand. But when the plan started falling apart, or Mitchell became a liability, Hand killed Mitchell to silence him and then staged the scene to appear as a home invasion gone wrong. The jury saw through the story. Hand was charged with aggravated murder, aggravated burglary, attempted cover-up and falsification of evidence, conspiracy to commit murder. He was convicted in 2003 and sentenced to death for the calculated murder of Donna Hand. The court cited premeditation, abuse of trust, and manipulation of others to kill as aggravating factors. Hand's legal team filed a series of appeals over the next 15 years, arguing his confession was obtained under coercion, improper admission of prior bad acts, the deaths of his former wives, ineffective counsel and jury bias, Brady violations, withholding of potentially exculpatory evidence. Each claim was denied at the state level and then again in the federal courts. In 2018, the United States Supreme Court refused to hear Hand's final appeal, effectively ending his legal road and paving the way for an execution warrant. By 2024, Ohio's Office of the Governor officially signed the order for execution to proceed on June 17, 2026. Gerald Hand is scheduled to be executed via lethal injection, Ohio's default method of execution. However, Ohio has faced multiple setbacks due to unavailability of lethal injection drugs and concerns from pharmaceutical manufacturers refusing to supply them for executions. That said, Hand remains among those prioritized for 2026 executions, with Ohio officials asserting they are working to resolve logistical matters to ensure the sentence is carried out. Hand's case has continued to raise ethical and procedural concerns. How were multiple suspicious deaths connected to one man not fully investigated earlier? Should older inmates, especially those over 70, still face the death penalty? Is a 20-plus year wait consistent with swift and certain justice? Victims' advocates, however, have pushed for resolution and closure, especially for Donna Hand's family, who called Gerald Hand a manipulator and a cold-blooded killer in a suit. Execution case, July 2026, Cleveland Ramon Jackson and Danny Lee Hill, Ohio. Who is Cleveland Ramon Jackson? Cleveland Ramon Jackson is a death row inmate in Ohio, convicted for his role in a deadly 2002 robbery that resulted in the brutal killing of 2 young children. His crime stunned the community of Allen County, and his name became synonymous with ruthless violence and cold-blooded execution. Now in his late 40s, Jackson is scheduled to be executed on July 15, 2026 by lethal injection, more than 2 decades after the crimes that sealed his fate. On the evening of January 3, 2002, Cleveland Jackson and his half-brother, Jerome Jackson, entered an apartment at 231 E Eureka Street in Lima, Ohio, to rob drug dealers they believed were keeping cash and narcotics on the premises. Inside the small apartment were 9 people, including 6 children, some of whom were unrelated to the drug operation and simply visiting. According to court records, the brothers brandished handguns, ordered the victims to sit down, and demanded money. When they weren't satisfied with what was handed over, the situation escalated. Cleveland Jackson then forced the victims to line up and open fire in a terrifying execution-style shooting. 2 children died. 3-year-old Jayla Grant shot in the head and killed instantly. 17-year-old Lanicia Williams shot in the neck and chest. 4 others, including a 10-year-old, were wounded but survived to testify. Prosecutors later revealed that Jackson reloaded his weapon during the shooting, emphasizing the deliberate and calculated nature of the attack. According to witness testimony, Jackson showed no signs of panic or hesitation as he gunned down innocent people, many of them pleading for their lives. Cleveland Jackson was convicted of aggravated murder, attempted murder, aggravated robbery, felonious assault. The jury recommended death, citing multiple victims, young age of victims, lack of remorse, Jackson's leadership role in the killings. He was sentenced to death in 2003. His half-brother and accomplice, Jerome Jackson, also received the death penalty, but his sentence was later commuted to life without parole after a resentencing process in 2021. Jermaine's lower culpability and defense claims of following Cleveland's lead were considered. Cleveland Jackson pursued numerous appeals over the last 2 decades, including direct appeal to the Ohio Supreme Court, denied 2005, post-conviction relief and habeas corpus filings in state and federal courts, review of mental health history and competency, ultimately rejected, claim of ineffective counsel rejected at all levels, petitions for clemency and sentence reduction, unsuccessful. In 2013, the U.S. Supreme Court refused to hear his final appeal, effectively clearing the path for execution. As of 2024, the state of Ohio scheduled his lethal injection for July 15, 2026, and no further delays have been granted. Jackson's execution is planned via lethal injection. The 2002 shootings left deep scars in the Lima community, especially among families of the child victims. Memorials have been held for Jayla and Lanicia over the years, and advocates have consistently pushed for Jackson's execution as a matter of justice and closure. At the same time, some anti-death penalty organizations have highlighted Jackson's troubled upbringing, alleging possible undiagnosed mental illness, exposure to extreme violence in childhood, and systemic failings in the justice system. These concerns, however, have not swayed the courts. Cleveland Jackson has not issued any public statements regarding his scheduled execution. However, his prior court behavior, including violent outbursts and refusal to cooperate during sentencing, suggests he may not go quietly. His legal team has not filed any recent motions for clemency or stays. Unless a significant legal intervention occurs, his execution is expected to be carried out as scheduled on July 15, 2026. Who is Danny Lee Hill? Danny Lee Hill is a convicted murderer from Trimble County, Ohio, scheduled to be executed on July 22, 2026 by lethal injection. His name is linked to one of the most gruesome and controversial killings in Ohio's recent legal history, the torture and murder of a mentally disabled teen in 1985. For nearly 4 decades, Hill has remained on death row, during which time his case became a national flashpoint over the execution of individuals with intellectual disabilities. After exhausting all legal avenues, Hill now faces the death penalty in 2026, unless a final intervention occurs. On September 10, 1985, 12-year-old Raymond Fife left his house in Warren, Ohio to meet a friend and deliver newspapers for his paper route. He never arrived. Later that evening, after he was reported missing, Raymond was found in a wooded area near a bike trail, barely alive. The details of the crime are shocking and have haunted Trimble County for decades. Raymond had been beaten with a belt and large rock. He was burned with cigarette lighters. His genitals were mutilated. A stick was shoved into his rectum. He had been strangled with his own belt and shoelaces. His clothes were partially burned, and he had been left for dead. Raymond lingered in a coma for 2 days before succumbing to his injuries on September 12, 1985. The level of cruelty stunned investigators and drew national attention. Who was responsible? Danny Lee Hill, then 18 years old, was arrested alongside his co-defendant Timothy Combs, a 17-year-old friend. Both had low IQs and both gave detailed confessions implicating themselves and each other. Hill told investigators he and Combs attacked Raymond out of boredom and rage. In a disturbing moment during his confession, Hill reenacted the crime for police, demonstrating how he and Combs carried out the mutilation and murder. He showed no remorse. Although Combs was a juvenile and could not receive the death penalty under U.S. law, he was sentenced to life in prison without parole. Hill, however, was legally an adult and was sentenced to death in 1986. Hill's case has drawn controversy due to questions about his intellectual ability. His defense team has long argued that he has intellectual disabilities that should make him ineligible for execution under the 2002 U.S. Supreme Court ruling in Atkins v. Virginia, which prohibits executing people with intellectual disabilities. Key points in the legal debate: Hill had an IQ between 68 and 71 on several tests, close to the cutoff. Psychologists disagreed on whether he met the threshold for adaptive functioning impairments. Prosecutors argued that Hill's ability to plan the crime, manipulate the scene, and evade capture showed that he understood his actions. In 2020, a federal judge ruled that Hill was not intellectually disabled under current legal standards. The U.S. Court of Appeals for the Sixth Circuit upheld the ruling in 2021, and in 2022, the U.S. Supreme Court declined to hear his final appeal. With that decision, Hill's legal remedies were officially exhausted, and the state of Ohio moved forward with scheduling his execution. Ohio has confirmed that Hill will be executed using the standard 3-drug lethal injection protocol, unless legislative changes or court orders intervene. Raymond Fife's murder remains one of the most brutal child killings in Ohio history. His parents, Robert and Miriam Fife, became lifelong advocates for crime victims, fighting for justice at every stage of Hill's appeals. The community of Warren, Ohio, has held annual remembrance ceremonies for Raymond, and the Fife family has repeatedly expressed frustration at the length of time Hill has remained alive. In contrast, death penalty opponents have voiced strong concerns about executing someone with low IQ scores, citing moral and legal risks, especially given how public standards around intellectual disability have evolved since 1985. Execution case, August 2026, James D. O'Neil, Ohio. Who is James D. O'Neil? James D. O'Neil is a convicted murderer from Hamilton County, Ohio, whose death sentence stems from the brutal 1993 killing of his estranged wife, Tanya O'Neil. After more than 30 years on death row, his execution is officially scheduled for August 19, 2026, by lethal injection. His case is remembered for its shocking domestic violence, prior criminal history, and the chilling circumstances surrounding the murder, all of which contributed to the jury's swift death sentence decision. On May 1, 1993, James O'Neil murdered his estranged wife, Tanya O'Neil, in her Cincinnati apartment, despite an active court order barring him from contacting her. According to police and court records, O'Neil broke into Tanya's home using a crowbar and attacked her in front of their 2 young children. He stabbed Tanya multiple times with a knife, including wounds to her chest and throat. She bled to death in her own bedroom, and the children, traumatized and screaming, were later found hiding in a closet. The motive was clear. O'Neil was furious about Tanya leaving him and had a history of controlling and violent behavior. Just weeks prior, she had filed for a protective order, citing repeated harassment and beatings. O'Neil's criminal record played a significant role during trial. He had been convicted of raping Tanya O'Neil during their marriage in 1989. He had served time in prison, then released under parole conditions that barred him from contacting her. In spite of those orders, O'Neil stalked, harassed, and eventually murdered her. Prosecutors emphasized how the system failed to protect Tanya, despite her taking all the legal steps to avoid her abuser. In 1994, O'Neil was convicted of aggravated murder, aggravated burglary, and violating a protective order. The Hamilton County jury deliberated on the aggravating circumstances of killing a person with whom he had a domestic relationship, prior conviction of violent felonies, killing in the presence of minor children, premeditation and malicious intent. He was sentenced to death, and the Ohio Supreme Court affirmed the conviction in 1999. Over the years, O'Neil's legal team pursued a wide range of appeals, including both direct and post-conviction reviews, but every attempt was rejected by the courts. Key appellate history: 2005 to 2011, habeas corpus filed in federal court; 2012, Sixth Circuit upheld conviction; 2014, U.S. Supreme Court denied certiorari; 2015-2024, multiple clemency efforts and mental health evaluations rejected. Notably, O'Neil's attorneys tried to argue childhood trauma, low intellectual functioning, and poor legal representation, but none of those arguments persuaded the courts. In 2024, Ohio set an official execution date of August 19, 2026, after years of backlogged executions due to drug shortages and legal uncertainty. Like other Ohio death row inmates, James D. O'Neil is scheduled to be executed via lethal injection. The death of Tanya O'Neil became a rallying point for domestic violence advocates across Ohio. Her murder exposed gaps in protection orders, parole supervision, and the failure to monitor high-risk offenders after release. Tanya's family has attended nearly every major hearing for 3 decades, fighting for the sentence to be carried out. In interviews, her sister described Tanya as a brave, kind, and beautiful soul who did everything she could to escape, but the system failed her. Her 2 children, both adults now, have remained out of the spotlight, though court records indicate they provided key witness testimony that helped convict their father. O'Neill has not submitted a clemency request as of August 2025, but the option remains open. His defense attorneys are not expected to mount further appeals unless major changes occur in Ohio's execution laws or supply chains. Barring intervention, his execution is expected to proceed on August 19, 2026. Execution case, October 2026. Jerome Henderson, Ohio. Jerome Henderson is a death row inmate from Hamilton County, Ohio, who was convicted in the late 1980s for the rape and murder of 27-year-old Rhoda Nathan, a crime that drew widespread outrage due to its violent nature and shocking location, a hotel room in suburban Cincinnati. Now, over 35 years later, Henderson is scheduled to be executed on October 21, 2026, by lethal injection, following decades of appeals that were ultimately rejected. His case is noted for its forensic significance, the targeting of an innocent stranger, and multiple claims of innocence, all of which have failed in court. On the morning of February 9, 1985, Rhoda Nathan, a guest at the Quality Inn Motel in Blue Ash, Ohio, was murdered in room 237, which she shared with a close friend while attending a family bar mitzvah, according to police reports. Rhoda had stayed behind while her roommate went down for breakfast. During that brief window, a man broke into the room, raped her, and fatally beat her with a hotel ashtray. The crime scene was bloody and violent. Rhoda's injuries included facial fractures, blunt force trauma to the skull, and defensive wounds. Witnesses saw a suspicious man, later identified as Jerome Henderson, loitering in the hallways that morning. Investigators tied Henderson to the crime through a combination of eyewitness testimony, fingerprints, and DNA evidence. His fingerprint was found on the room's television set, which he could not have accessed without unlawfully entering. Semen evidence from Rhoda Nathan's body was later tested and found to be consistent with Henderson's DNA, although earlier DNA methods in the 1980s were less precise than today's. Motel staff and guests identified Henderson as the man wandering through the corridors, knocking on doors under false pretenses. Police discovered that Henderson, who had prior convictions for robbery and assault, matched the suspect description and had no lawful reason to be on the premises. He was arrested, tried, and sentenced to death in 1986, with the jury citing the rape-murder combination as sufficient aggravation under Ohio's death penalty statutes. For over 3 decades, Henderson pursued every available legal channel to overturn his conviction and sentence. His defense argued contamination of DNA evidence during initial testing, misidentification and unreliable eyewitness statements, poor legal representation during the 1986 trial, claims of innocence and wrongful conviction, particularly as DNA science advanced. In 2011, Henderson's attorneys pushed for a new trial based on newly interpreted DNA evidence. However, a Hamilton County judge ruled that the totality of evidence overwhelmingly confirmed his guilt. The Ohio Supreme Court upheld his conviction, and in 2016, the U.S. Supreme Court denied certiorari, effectively ending his legal journey. Henderson is set to be executed by Ohio's standard 3-drug lethal injection protocol. Unless the state suspends executions again, Henderson is expected to be put to death at the Southern Ohio Correctional Facility in Lucasville. Rhoda Nathan's murder shocked the Jewish and business communities in Ohio. Her family has been vocal throughout the legal proceedings, attending many hearings and opposing efforts to overturn the conviction. At sentencing, her son described the crime as a barbaric act of cowardice against a peaceful woman just trying to enjoy a family celebration. Her murder has since become a reference point in discussions around hotel safety, forensic evidence, and capital punishment. As of 2025, Jerome Henderson has not submitted a clemency request, and there are no active stays in place. His legal team has not signaled any additional filings or challenges. Unless unexpected judicial intervention occurs, Henderson will be executed as scheduled on October 21, 2026, bringing closure to a case that began over 40 years ago. Execution case, November 2026, Melvin D. Bonnell Jr., Ohio. Melvin D. Bonnell Jr. is a death row inmate in Ohio, convicted of a 1987 murder in Cleveland, located in Cuyahoga County. Now in his 60s, Bonnell is scheduled to be executed on November 18, 2026, by lethal injection, after more than 35 years of legal battles and a long history of appeals that culminated in final denial by the courts in 2007. His case stands out due to its lengthy litigation, Bonnell's persistent claims of innocence, and missing evidence that some say raises questions about Ohio's handling of death penalty cases. On the night of November 28, 1987, police were called to the apartment of Robert Bunner, a Cleveland resident who had been shot twice in the chest at close range. He was found alive but critically injured and later died at the hospital. According to trial testimony and police reports, Bonnell, who knew Bunner casually through mutual friends, had visited the apartment that night. Witnesses claimed Bonnell was high on drugs and alcohol. He had argued with Bunner earlier in the evening. Neighbors heard shouting, followed by 2 gunshots. Bonnell allegedly fled the scene and confessed to multiple people shortly after. Police later recovered a .25 caliber handgun, and forensic evidence reportedly tied Bonnell to the crime scene. He was arrested within days and charged with aggravated murder, aggravated burglary, and having a weapon under disability due to a prior felony conviction. At trial in 1988, the prosecution painted Bonnell as a violent drug user who murdered Bunner during a dispute over drugs or money. They highlighted Bonnell's alleged confession to 2 witnesses, forensic evidence linking him to the scene, his criminal history, including prior assaults. The defense argued there was no direct eyewitness to the shooting and questioned the reliability of the confessions. Nonetheless, the jury found Bonnell guilty and he was sentenced to death. Bonnell's case became a legal saga over the next 3 decades. His lawyers argued that several key pieces of physical evidence, including biological samples, were lost or destroyed by Cleveland police, preventing further DNA testing. He may have been wrongly convicted based on circumstantial evidence. Alleged confessions were either fabricated or coerced. In 2007, the U.S. Supreme Court denied his final appeal, officially ending his direct appeals. Bonnell continued filing post-conviction and habeas petitions, citing the absence of DNA testing and the need for modern forensic review. In 2020, Bonnell's legal team filed a motion to reopen the case, arguing that new testing technology might exonerate him if physical evidence still existed. But the court ruled that too much of the original evidence had been destroyed or was unavailable, and his conviction stood. As of 2024, the state of Ohio set his execution date for November 18, 2026. Bonnell's legal team has repeatedly emphasized that evidence including clothing, a rape kit, and DNA swabs were mishandled or lost. This violated his right to due process and access to post-conviction forensic review. Without that evidence, the court should halt the execution. The Ohio Innocence Project and other advocacy groups have cited Bonnell's case in calls to improve preservation laws, arguing it represents how missing or mismanaged evidence can lead to irreversible outcomes in capital cases. Nonetheless, courts have ruled that his conviction remains legally sound based on trial evidence and testimony. Bonnell is scheduled to die by lethal injection. While the victim's family has remained largely private, legal scholars and advocacy organizations continue to cite Bonnell's case as emblematic of flaws in Ohio's death penalty system. Concerns include lack of forensic review, lost evidence, execution despite unresolved questions. Still, prosecutors and Ohio courts have reaffirmed that Bonnell received a fair trial and that his conviction is based on solid admissible evidence, including confessions and physical presence at the scene. Beyond Ohio, other U.S. states, including Alabama, Tennessee, Indiana, and Florida, have inmates eligible or pending for execution in 2026, but no firm dates have been established at the time of writing. These pending cases are often awaiting final rulings on appeals or motions, a signed death warrant by the governor, litigation around execution protocols, especially for states exploring new methods like nitrogen hypoxia or firing squads, supply or procedural issues tied to lethal injection drugs. It can be observed that there is lack of executions in some months of 2026, such as January, April, May, September, and December. This reflects broader systemic issues. Execution dates depend on multiple layers of legal, political, and logistical factors, including exhaustion of appeals, availability of drugs or approved execution methods, scheduling capacity at designated facilities, court-issued stays or intervention from governors, shifting public opinion and political will. In states like Ohio, where 8 executions are scheduled between February and November 2026, the calendar itself is a tightrope, with execution timelines vulnerable to being delayed, stayed, or vacated due to ongoing legal battles or administrative hurdles. While this list captures the known and scheduled executions as of now, additional cases may emerge or shift depending on the legal outcomes ahead. The 2026 execution calendar is fluid, and many of these cases remain subject to last-minute reversals, reprieves, or legal challenges that have become a hallmark of modern capital punishment in the United States. If you found this breakdown illuminating, subscribe for more investigative content. Share your thoughts. Should the death penalty persist? Which of these cases resonated most with you? Thank you for watching. Join us next time for another deep dive into the hardest questions in American justice.